we have the notice period. The notice period is important when you terminate an employee's employment agreement, because there are certain ways for termination. We will go into them a little bit more later on in the presentation. But if a contract ends automatically, a fixed term contract ends automatically, nothing needs to be, or something needs to be done. We will talk about that later as well. But it will end, so you don't have to give notice in the sense of this sheet. However, if a fixed term contract, if you want to end it prematurely, there needs to be a clause in the contract saying that premature termination is even possible. If you don't have that clause, it's going to be difficult. But if you have that clause, premature termination would be possible, and termination of indefinite contracts, of course. In both situations, you need to uphold the notice period. And the notice period for the employer depends on the duration, the length of the employee's service. So if someone has been employed by the company for less than 5 years, it's 1 month, 5 to 10 is 2, 10 to 15 is 3, and more than 15 years would be 4 months. And from the employee side, it is 1 month. So if an employee wants to resign, they need to uphold a notice period of 1 month. If you don't do that, if the employee does not do it when resigning, if the employer does not do it when terminating, the other party has a right to ask for compensation for not upholding the notice period correctly. However, there is a deviation possibility. That needs to be agreed upon in writing again, so we come back each time to having a written agreement in place. Sometimes it is just not sufficient time to find a new candidate, and 1 month notice period is a very short amount of time. If an employee does give notice on the 30th of November, you only have 1 month to search for a new candidate and person and have him employed. So it is possible to agree to a longer notice period for the employee, so let's say 2 months. However, that does mean that the notice period of the employer is automatically doubled. So 2 months for the employee means 4 months for the employer. If you do not word that correctly in the employment agreement, and I see that quite often, is that a notice period clause is in the contract saying 2 months for the employee, 2 months for the employer. That is not double, so it's incorrect, but that also means that an employee can either choose to say, I have 2 months, so you have 4 months, or the employee could say, well, it's wrong anyway, so I just will have 1 month, and that is the legal situation, and I'm going to resign with only 1 month. So make sure that if you deviate, that the deviation is correctly included in the contract. If a CLA is applicable, deviations are possible as well. And a notice period, as I mentioned before, is not necessary if the contract automatically ends at the end of the duration. In the probation period, you do not have to uphold a notice period. It is immediate. And if the employment contract is ended due to urgent cause. So that's firing on the spot or at will employment, sort of similar. You don't need to uphold a notice period.